Hi, I'm attorney Joe Pujol.
And I am Julius Seiler.
Welcome and thank you so much today for attending our estate planning webinar.
Today we're going to go through some real life examples of what's happened to families in our practice.
All right, so let's get going. Let's begin. This is Estate Planning 101, what every Florida family should know. But first, let us introduce ourselves a little bit. So I'm Joe Pujol. I've been practicing real estate law and estate planning for approximately 30 years, specifically about 27 and a half years. During that time, I've handled literally over 20,000 transactions. I've personally supervised and been involved in them. Julius, go ahead and join us.
Thank you, Joe. I am Julius. I've been with Joe for almost 20 years with a lot of experience at the firm. We've done, as Joe has said, real estate and estate planning. Our focus primarily is on families with young children, and we're here to educate you today.
But first, as a thank you from us for attending our workshop, we would like to offer you a complimentary one-on-one phone call with us to talk about you and the people you love the most and how you can protect them. Please stay to the end and you will have the opportunity to schedule a phone call with me.
Pujol Law is your estate planning law firm, trusted by families like yours. With over 100 five-star reviews, we know how to get it done for you. When we meet with clients for the first time, we listen to their concerns and ask about their family dynamics and what their goals are. From there, we discuss with them, based on the information that we have obtained and the documents they have in place or don't, we tell them what would happen to their family and assets if something happened to them that day. Once they've been educated, most families are enlightened and understand that they have to do something. They have to put a plan in place in order to protect their loved ones, to avoid probate, and give themselves and their loved ones peace of mind. Just as important as that, families must have a comfort level with their attorney, which our reviews indicate they would have. All of our clients feel at home with us, and you could too at Pujol Law.
Before we start talking about estate planning, everyone must understand the simple truth. The truth is, planning your estate isn't about your needs. It's about protecting the people who count on you. So who needs an estate plan? Look, it doesn't matter if you're young or old, if you have built up considerable wealth, if you just have a few assets. You need a written plan to protect your loved ones and yourself. Life can be messy, and estate planning is about keeping the mess from becoming a nightmare for your spouse, your kids, your loved ones, and yourself. So if you have any assets, like a house or a business or bank accounts or a car, you should have a basic plan in place. It doesn't have to be a complex plan, just a basic one. Young adults who will eventually have children, married couples, anyone seeking peace of mind, all you need to have in place is a basic plan that will keep you out of court and out of conflict. Now let's look at some examples of why everyone needs an estate plan. So let's welcome the Smith family. Congratulations, John Smith has graduated high school. He's now a legal adult. Mom and dad are super happy. Realistically, John, even though he's only 18, should have some basic documents in place, but he doesn't. Let's look at that later on. But for now, he's graduated high school, so let's celebrate. Now, while celebrating, John had gone out with his friends, but unfortunately, the driver ran a red light and hits John's car, hospitalizing John. Now look, everyone, this can happen to any of us. It doesn't have to be a car accident, but any day, every day, people have car accidents. Any one of us today could be involved in a car accident. We could be involved in a trip and fall, or just some simple or complex health episode. Now, as any concerned parents, Mr. and Mrs. Smith urgently go to the hospital. They get to the hospital and they see their son, John, laying in the hospital bed, and they ask about his condition and what's wrong with him. But unfortunately, due to the HIPAA laws, and guys, the HIPAA laws are the ones that protect our medical privacies. And guess what? John, he's 18 now, so they apply to him as well. He's an adult. It means they can't give mom and dad any information. Imagine if your child's in the hospital and you're not allowed to know their medical condition, even if it's just temporarily, even if it's just for a few minutes, an hour, or a day. It would horrify every parent. I know it would horrify me. I have children. However, there's good news. We can avoid this situation with proper planning. Now, how could you prevent this bad day from getting even worse? Well, the answer is with proper planning. Once John turned 18, he should have signed 3 documents. He should have had 3 legal documents in place. It's important to mention that these documents are not just for young adults. Everybody should have these in place. Getting back to John though, does a college student really need an estate plan? Well, the answer is it kind of depends, but yeah. A plan can be complex or simple. Now, he should have a simple plan in place. And by this, I mean when your kid turns 18, they are legally adults. Remember that. When your son or daughter gets close to 18 years old, they will be powerless in an emergency. And by powerless, I mean if they end up in a hospital, whether temporarily or seriously or a minor accident, three things are going to happen. One, you can't make medical decisions for them. Two, you can't access their bank accounts. And three, you can't even get updates. The hospital won't care that you're the mom or dad. The HIPAA laws protect them, and the hospital cannot give you any information. So an 18-year-old doesn't really need a trust or a will, but they do need a financial power of attorney, a medical power of attorney, or an advanced healthcare directive. Without these, you're just stuck in the dark, waiting and hoping, and possibly ending up going to court, which is what always happens without a plan. Now that we know the importance of a financial power of attorney, a healthcare power of attorney, and an advanced healthcare directive, well, let's move on to the next example.
Let's welcome the Miller family. George and Diana are considering marriage, a wonderful time in their lives. But the furthest thing from their mind is the possibility of a divorce. But it may be on the mind of George's and Diana's parents. Why? Because either family may be well off financially and have a number of assets to pass on to their soon married children when they pass away. In order to provide peace of mind to George's or Diana's family, a prenuptial agreement may want to be considered. And if done before the engagement and done tactfully, this prenup can avoid future issues should a divorce come into play. George and Diana are also urged to consider having basic documents in place, such as a financial power of attorney and healthcare power of attorney documents as well, in case they were both incapacitated on their honeymoon or any time thereafter. You would certainly want your children to be protected in case of the unimaginable, but the wedding is at hand and everyone wants to celebrate. Okay, the wedding day is here. What a joyous occasion. Life moves on. As we continue our story, Diana and George are now expecting their first child, Anna. George is doing well financially, and so they are looking forward to moving into their first home together. But remember, George and Diana still don't have a plan in place, yet they're taking on the responsibility of a new baby and a new home. And now they're urged to get these plans in place and documents in place even more. With Anna coming, they're advised to get guardianship documents in place in case of the unexpected. That's right. What would happen if those guardians are needed? We move on with our story. One night, George and Diana go out on a well-deserved date night. Then the unimaginable happens. There is an accident, and both George and Diana are incapacitated. Oh my goodness, poor Anna. And to make matters worse, George and Diana never did get around to creating guardianship documents for Anna. So when the authorities come on scene, it's realized that there are no officially designated guardians to watch over Anna. The Department of Children and Families were called in to take Anna into Child Protective Services. Very sad indeed, as this was easily avoidable with proper planning. Now a court and a judge have control over what is to happen to Anna during her parents' incapacity. So how could you have prevented a bad day from happening? Well, George and Diana could have created an estate plan, legally setting parameters of who was to take care of their financial and healthcare matters in case something like this were to happen. They also could have selected legal guardians for Anna so that Child Protective Services could have been avoided and Anna not suffered even more trauma when a loved one could have taken care of her, not a court nor strangers. The moral of the story? Make your plans and have them in place before this happens. Young families need documents in place in case both adults are incapacitated. Or, should they have young children, those documents as well. Legal guardianship documents must be in place to prevent such a scenario. At Pujol Law, we will take care of all the necessary documentation as we plan to keep your family out of court and conflict and provide you peace of mind now and for the future.
For our last example, I'd like to welcome the Garcia family. Let's get to know the Garcias. Mr. and Mrs. Garcia have 2 adult children, Luke and Sophia. Mr. and Mrs. Garcia also have multiple assets, including a house valued at $500,000, about $250,000 in the bank, and also 2 cars. However, the Garcia family has made the mistake of not having what? A plan in place. Let's say now that Mr. and Mrs. Garcia go on a date night. And unfortunately, this time there is a bad accident and they don't make it home. They will not make it home. A driver ran a red light and Mr. and Mrs. Garcia were hurt and died in the accident. It's unfortunate, but it happens. It happens every day. We try to avoid it, but it happens. Let's get back to the Garcias. In this case, we want to ask ourselves, what will happen to their assets? What will happen to their children? Well, most people believe that it will be simple and that Mr. and Mrs. Garcia's assets will be equally dispersed between Luke and Sophia. Since there's no estate plan in place, the assets go to probate court. And probate is one of those places you need to avoid at all times. The probate process is time-consuming and costly. In probate court, a judge decides who gets what percentage of your assets. This potentially means that Mr. and Mrs. Garcia's relatives and friends and family and maybe even neighbors will argue to a judge, to an unknown party, about who should get what assets and who was entitled to what. Now, this means that Mr. and Mrs. Garcia's wishes will probably not get fulfilled as they intended. But besides this, another issue is that in probate court, there are many court costs and fees. And in the Garcia family's case, based on their assets, they'll be paying anywhere from $30,000 to $40,000 in court costs, monies and resources that could have gone to their children instead. So before we move on, let me spend a little more time on this slide. It's an important matter we're talking about here. Let me be blunt. If you die or get disabled without a plan, your family gets courtrooms, confusion, and a legal mess. If you have no will, the state hands out your assets and resources. If you have no guardianships, a stranger decides who raises your kids. If you have no power of attorney, your bank accounts are frozen when your family need them most. A basic estate plan isn't about fear, it's about control. You worked for it, don't let the system tear it apart.
So why do we want to avoid probate court? Several reasons. We want to avoid family conflict, which often happens without clear guidelines. What Joe has quickly learned is that where there's a will, there are relatives, and probate court. Another reason is that probate is a lengthy public court process. That's right, probate can last up to 2 years or longer if a will is contested. Anyone can learn of what your estate has, how many properties, how much money your heirs will be inheriting, and when they will be inheriting. Do you really think this is wise? There are villains out there who troll the probate court dockets, looking for young adults who will be coming into money, to prey on them with alluring and often bogus business deals. Not to mention the older adults who may be scammed easily when those con men are there to help them part with their inheritance. Don't let this happen to your family. Create a trust which will avoid probate. The expense of probate, as Joe has mentioned, is staggering. From court costs, court fees, bond fees, appraiser fees, and attorney fees, a probate could cost 5 to 8% of your probatable estate. That's right, 5 to 8% of what your assets are valuated at. In this example, at least $30,000. Remember, if you create a living trust, assets are given to their heirs the way you choose, the way you want, and when you desire them to have it. It avoids probate, and which eliminates court and conflict.
Fortunately, the probate mess is completely avoidable. All you have to do is create a proper estate plan, a basic plan. But you have to do this before it's too late. Procrastination is a major issue, and it is one holdback for most people. To truly show you how much better it is to create a proper plan and have a plan in place than just going to probate court and leaving it up all to the wind to see where it falls, let me show you the cost of doing each. All right, so up here you see we have 2 columns. We have the Pujol office option and the probate court option. So let's look at our option. Well, it's talking about the cost here. It says $1,200 to $8,000. That's from the low end to the high end. The high end there, we're talking about complex planning, LLCs, and other matters. But let's stick to the simple stuff. And by the way, a college plan could be less than the simple stuff. But let's just look at a basic plan. A trust. There's no family conflict. Everything's determined. You leave your instructions. It all takes place. Assets and resources are available immediately. Sometimes we talk about money, but money's just a resource. It's what allows you and your heirs to complete what needs to be completed. A trust is completely private. Again, you choose where your assets go. You decide. And you even decide how your kids are raised and who raises your kid. That's our option. Now, if you leave it up to the court, to the probate court, you're looking at expenses. It says $30,000 there, but it really depends on your net worth. If you have a home, if your home's at $700,000, something like that, or if you have about $700,000 in total assets, yeah, you're looking at about $30,000, $40,000, $50,000. It could be much more. But in probate court, again, family conflict is involved. There's arguments with members, relatives, and the court itself. Assets are tied up for about 19 to 18 months and could take longer. It says 9 to 18 months there, but it could take up to 24 months, and in complex matters, even a few years. Probate is public versus a trust that was private. Judge chooses who gets your assets. In other words, the state decides. You don't get to decide. And yes, the state even decides how your kids are raised. The state decides who raises your kids and how they're raised. You don't have a say. So that was reviewing the trusts and keeping you out of probate. Now let's look at why we always recommend trusts over wills. So up here on the slide, you'll see on the left-hand side trust and on the right-hand side will. Let's look at the will side first. Like I mentioned, wills, well, having a will is almost like not having a will. A will still goes to probate. And again, we want to stay out of probate because it's expensive. It takes potentially a couple years or longer, ties up your assets, and it only takes effect after your death. In other words, if you're incapacitated, if you're in the hospital, a will does nothing for you. It's just there waiting until you pass away. And the last thing with a will, wills are public. Everybody sees what's in there, whether it's the public at large, financial predators, or just your neighbors. Now let's compare this or contrast this to the trust on the left-hand side. Number one reason most people have a plan in place, because trust avoids probate. You don't go to the court. Everything is private and you keep it there. Which means, if you follow the reasoning below this, is the trust takes effect immediately. It doesn't matter if you're incapacitated. Trust decides what happens. It decides what happens because you put your decisions in there. You don't have to wait till you pass away. The trust takes effect immediately. The day you prepare it, that's it. It's effective. Which means the trust has incapacity planning. If you end up in the hospital incapacitated, whether permanently or even just temporarily, the trust says and dictates what your wishes are. And those wishes, guess what? They have to be carried out. That's what the trust says. And finally, trusts are private. They're not shared in the court. They're not recorded. Nobody knows what's in there other than yourself and who you designate.
So what if a divorce is to happen? Remember George and Diana Miller? Remember they were getting married? And either of them could have come from a family with means, perhaps even wealthy? Keep in mind that a major cause of divorce in this state is an inheritance. Divorces don't need any incentive, as almost half of marriages end in divorce to begin with. And inheritance increases that number to 60%, while second and third marriages, divorce rates go up to about 70%. But let's focus on George and Diana. Without that prenuptial agreement in place, either divorcee stands to lose 50% of their inheritance if it is deemed to be a marital asset. This is why we encourage that inheritances not be commingled between spouses, or you face the possibility that their inheritance is cut in half in a nasty divorce. Completely avoidable with proper planning. The trust documents prepared at Pujol Law contain divorce language so that only the intended spouse receive those monies and is encouraged to keep those funds separate, avoiding commingling the assets, and we assure that only their heir and their heir's descendants receive the inheritance set aside for that spouse.
All right, everyone, so we're almost here at the end of our presentation today, but first let me get to this. It's important you create an estate plan before it's too late. Anything can happen at any time, as we've seen in several examples today, and it's important that you plan for it as soon as you can. By creating the plan, you make sure that your wishes are fulfilled, on top of giving yourself and your family peace of mind. Most importantly, you will be able to leave your family knowing that you protected the people who rely on you the most. I want to review this one more time because this is really the important part of it. Imagine if something happens to you tomorrow, even if just temporarily. Would your spouse, your children, or parents know what to do? An estate plan isn't just for the wealthy. It's about protecting your family. It's about making sure your wishes are honored, and it's about avoiding costly legal battles in probate. Without a plan, the courts decide who gets what and when, and who raises your kids. But remember, a plan gives you control, peace of mind, and leaves a legacy. Don't let procrastination or decision paralysis leave a mess behind. Take steps today and take care of what matters most. Since we're nearing the end of our session today, it's finally time to tell you how to obtain your complimentary 20-minute call with us. Simply call this number, 305-447-0059. Let me repeat that, 305-447-0059, and tell us that you watched our Estate Planning 101 workshop. Thank you so much for your attention today. And if you have any further questions, you can either call us or even just walk by our office. Come in and stop by. I also encourage you to follow us on our social media. We regularly post content and information on everything about estate planning and real estate too. Thank you for being here with us today. That's the end of our presentation. Hopefully you've gotten some important information, but don't worry. If you can't remember something, just follow up, give us a call.
Thanks, Joe. That's absolutely correct, guys. It was a lot of information today, and we hope you absorbed some of it. Our job was to educate you today, and I hope we've done that. We look forward to seeing you in our offices soon.
Goodbye, everyone.